Institutional fiduciaries operate in an environment defined by continuity, compliance, and long-term stewardship. Trust administration is not episodic. It is an ongoing operational responsibility that must withstand regulatory scrutiny, beneficiary review, and the passage of time. As trusts increasingly hold diversified asset classes across multiple jurisdictions, fiduciary risk is no longer limited to investment performance. It extends administration itself, notice compliance, accounting standards, tax reporting, bonding decisions, and jurisdictional coordination. This video addresses how multi-state trust administration impacts institutional fiduciaries and how coordinated legal oversight supports stability and continuity. Hi, I'm Ben Vojtik. I'm a partner at the Hartley Law Group. I'm licensed to practice in Texas and California. Let's start with institutional trust administration, continuity, compliance, risk management. Modern trusts frequently span jurisdictions. Real estate may be located in one state, beneficiaries in another, and administration centralized elsewhere. Each jurisdiction introduces distinct statutory requirements, enforcement mechanisms, and timelines. For institutional fiduciaries, the challenge is not simply knowing the law of one state, but ensuring that administration remains coherent across all applicable jurisdictions. Fragmented legal advice, inconsistent interpretations, or delayed local filings create operational risk and exposure, institutions to surcharge, regulatory criticism, and reputational harm. Multi-state complexity. Multiple governing laws, asset-based jurisdictional triggers, overlapping deadlines. Texas and California frequently intersect in an institutional trust administration. Texas favors independent administration with fewer routine court filings, while California imposes detailed statutory notice and disclosure obligations. In California, trustees must comply with Probate Code 16061.7. requiring formal notification by trustee and triggering strict objection timelines. In Texas, beneficiaries may demand accounting under Texas Trust Code 113.151, with enforcement driven largely by beneficiary action rather than routine court oversight. Institutional fiduciaries must ensure that compliance in one jurisdiction does not inadvertently create exposure in another. Texas versus California administrative posture. Texas, independent administration, beneficiary-driven enforcement. California, statutory notices, deadline-driven enforcement. Bonding is a governance issue as much as a statutory one. Texas generally does not require trustee bonds unless mandated by the trust or ordered by a court. California permits bonding unless expressly waived and grants courts broad discretion. For institutional fiduciaries, bonding decisions are evaluated not only through statutory compliance, but also through internal governance, regulatory expectations, and reputational considerations. Proactive bonding analysis, documented and revisited as trust circumstances change, demonstrates prudent fiduciary oversight and mitigates downstream risk. Bonding as risk management, statutory requirements, internal governance standards, and reputational protection. Effective multi-state trust administration requires coordinated legal oversight. Institutions benefit from legal partners who can operate across jurisdictions without fragmenting strategy or fiduciary control. Multi-state licensed counsel provides continuity in Texas and California, while pro hoc vice admission, when court access is required elsewhere, allows institutions to preserve unified oversight while complying with local procedural rules. This approach supports consistency in notices, accountings, pleadings, and beneficiary communications. Unified oversight model, centralized fiduciary strategy, multi-state legal capability, and targeted local court access. Continuity over time, institutional fiduciaries are defined by their ability to endure. Administration must remain stable despite personnel changes, evolving asset profiles, beneficiary turnover, and regulatory scrutiny. Law firm-led fiduciary support reinforces this continuity, ensuring that institutional knowledge, compliance, systems and jurisdictional awareness are preserved over time. Long-term stability, institutional memory, regulatory resilience, and defensible administration. For private fiduciaries and financial institutions, trust administration is a reflection of governance, discipline, and credibility. Coordinated multi-state administration, supported by experienced legal oversight, protects institutions, beneficiaries, and reputations over the long term. The key takeaways: multi-state administration is an operational reality. Coordination reduces risk, continuity builds trust. I'm Ben Vojtik. To see the full video on this subject, please check out the link in the description.